Just go back outside, see if somebody else showed up. Okay. There's somebody right there. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Your case is a criminal case. County Court at Law Number 2, we handle misdemeanor cases. Criminal cases are divided into felonies or misdemeanors. Your felony cases are commonly referred to as your more serious type of offenses, whereas your misdemeanor cases are referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I mean, what I'm talking about is facts of the case and the possible punishment that a person can receive if they're convicted of the offense. Felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. We start at the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is a minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. If a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because, as I mentioned to you, the case that you have in this court is a misdemeanor case. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. You can be assessed a fine that does not exceed $500. Now, if you fail to pay the fine or the court converted your fine to what we call community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. That is a warrant for your arrest for you to either pay the fine or sit out the fine in jail. You'll receive $100 for every day, $100 credit toward your fine for every day that you sit out in the jail. The next level of misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days or 6 months in a county jail, a fine that does not exceed $2,000. Or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the state penitentiary, in the county jail, and a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, You have rights. And I will go over some of the rights that you have as a criminal, as a defendant in a criminal case. First right that you have that we're going to talk about is your right to have an attorney. On the clipboard that has been handed out, the first document should be titled Judge's Explanation of Rights to Defendants Without an Attorney. And I will go over this document with you. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may waive your right to attorney, which means you can give up your right to an attorney and represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset will means that you'll be given another court date to give you time to hire an attorney. If you want an attorney to represent you, but you do not have the money to hire an attorney, you will have to fill out a financial questionnaire to request that an attorney be appointed to represent you. Now, the financial questionnaire is a document on the clipboard that is titled Jefferson County Affidavit of Interest. You'd have to fill out the first page and half of the second page. And then the court will review that document to see whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. The third option is you can waive your right to an attorney and represent yourself. If you waive your right to an attorney and represent yourself, you'll be allowed to talk to the prosecutors. The prosecutors are assistant district attorneys who work for the Jefferson County District Attorney's Office. Before you're allowed to talk to them, you must first fill out a written waiver of your right to be represented by an attorney. The written waiver is the second document on the clipboard that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. I will go over that document with you in a few minutes. Now, before I do that, I need to inform you that you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, that is, if you decide to waive your right to an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, it states, defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney or give up your right to have an attorney to represent you, and you would like to represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant, and you will date it today's date, March 19th, 2024. Now, for those individuals who will be waiving their right to an attorney, I'm going to go over the document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. That means that you're doing it of your own free will and intelligently that means that you know what you're doing. So it says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 19th day of March of 2024 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, March 19th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, listen to the arguments, they will deliberate, and then they will decide to find you either not guilty or guilty of your charges. You also have a right to waive your right to a jury trial or give up your right to have a jury trial. If you do so, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a trial. We call that a bench trial. A bench trial is a trial without a jury, and it's a trial before the judge. The judge will listen to all of the evidence. The judge will listen to all of the arguments, and then the judge will decide, based on the law, to find you not guilty or guilty of your charge. The other way that your case can come before the court is by way of a plea bargain. It can come before the court by way of an unagreed plea bargain. A plea bargain is an agreement that you have worked out with the state to settle your case. If you are unable to work out a settlement or a plea bargain with the prosecutors to settle your case, then we call that an unagreed plea bargain. And then that case will still come before the judge. And the judge can do one of 2 things. At that point, the judge could assess the punishment within the punishment range of your case. Now, the other way that your case will come before the judge is by way of an agreed plea bargain agreement. The agreed plea bargain is that you and the state have reached a plea bargain agreement, and then it will come before the judge. The judge can do one of 2 things. The judge can either accept or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, then at that point, you will have the option to withdraw, which means to take back your plea. For example, let's say you and the state have worked out an agreement and the state has agreed to give you, say, 10 days in jail. And it comes before the court, the judge says, well, I'm not going to follow that plea bargain agreement. And then you say, well, judge, I withdraw my plea bargain agreement, or I take my plea bargain agreement back. You can do that. Now, if the judge follows the plea bargain agreement, and if you decide that you would like to appeal your case because you feel like you've been wrongfully convicted or the court has committed an error by convicting you, you have to get permission from the judge to appeal your case. And if the judge gives you permission, then your case will go to the 9th Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then at that point, you can appeal it to another court. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. And what that means is, pro se means you'll be representing yourself, and you'll be asking the Texas Court of Criminal Appeals to review your case. to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court has committed an error by convicting you. They can do one or two things. They can grant your pro se petition, and if they grant it, then they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. The other thing that they can do, they can reject or deny your pro se petition. If they reject or deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. You have a right to call witnesses in your case. Witnesses will sit in that chair that has the microphone in front of it. What witnesses will do, they can testify for you, against you. You can ask them questions if you're representing yourself, or your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you also have a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify in your case. The state, the government, district attorney's office cannot force you to testify in your case if you exercise your Fifth Amendment right against self-incrimination. Now, if you elect to testify, you can testify in your case. Now, as I mentioned earlier, you have a right to call witnesses. Now, if you do not call witnesses, you have a right not to call witnesses, but that does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. The other right that you have a right to have discovery. Discovery is you have a right to see the state's evidence, the evidence that the state will be using against you. You have a right to see witness statements, your statements, lab reports, police reports. You have a right to see video recordings, listen to audio recordings. You have a right to view and examine any instruments that the state will be using in your case. You also have a right to waive or give up your right to have discovery. Now, as a defendant in a criminal case, everyone that's here, you're here because you have been arrested and you're out on bond. And you're either out on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of the jail. Or you're out of jail on a PRR bond or a personal recognizance bond, which means that you do not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear in court. Now, every day that you spent in jail, if you spent 1 minute in jail, that's considered a day. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you're in the state has reached a plea bargaining agreement for you to serve 5 days in jail. That simply means that you will not have to serve any more time in jail, because you'll be given credit for the 5 days that you've already spent in jail. Therefore, you'll be given credit for time served. Now, every day that you spent in jail can also be used toward your fine and court costs. You will receive $100 toward your fine and court costs for every day that you spent in jail. So therefore, if you spent 5 days in jail, you in the state have reached a plea bargaining agreement for you to pay fine and court costs of $500, that means you won't have to pay it. Why? Because your 5 days in jail, with the 5 days that you spent in jail, you have accumulated $500 that will go toward your fine and court costs. Now, if the fine and court cost is $700 and you spent 5 days in jail, that means you would have to pay $200. Now, if you cannot pay the $200, then we can convert the $200 balance to community service. And every hour that you perform community service in a nonprofit organization in our community, you will receive $12.50 that will go toward your fine and court costs. So if you work 8 hours, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program for first-time offenders. That program is called pretrial diversion. And if you have never been in trouble before, the Jefferson County District Attorney's Office has this program. And if you qualify and get into the program, they will dismiss your case. And when you complete the program, you can get the case expunged from your record. Expunged means erased, wiped off, or deleted from your criminal record. In essence, it's like it never happened. Now, in order to qualify for the program, you have to have an attorney to assist you at getting into the program. And 2, it has to be your first time getting into trouble. And 3, it cannot be for an offense that involves unlawfully carrying a weapon or resisting arrest. For all other offenses, you may qualify for the pretrial diversion program. Now, if you are a veteran of any one of the military branches, Jefferson County has a program that is called Veterans Court. It's for veterans only. And with that program, once you get into the program and complete the program, they will dismiss your case and you can get what is called a non-disclosure. Non-disclosure basically means that your record will be sealed to the general public. Now, the government can have access, but the general public cannot have access to your record. Now, Jefferson County Court at Law number 2, this court, we have a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so with that program, we have partnerships with local agencies in the Jefferson County area. One of the partnerships that we have a partnership with Spindletop. Spindletop is our local mental health center. And with the Spindletop Center, Spindletop has the ability to do, they'll do a private interview either in the jury room, or they can do it at their facilities, or they can do it over the phone, depending on what is comfortable with you. Spindletop will also be able to do what is called an assessment, and they can develop a treatment plan, either for outpatient or inpatient services. Now, in order to qualify for that program, you do not have to be incompetent or insane. You can just merely suffer from anxiety or depression, and they'll be able to address your and any other mental health illnesses or sicknesses. They'll be able to address your mental health issues. Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Assessment and referral. With those programs, what those programs would do, both of those programs are drug and alcohol recovery programs. They can do screenings, assessment, and they can refer you to either outpatient or inpatient treatment. Now, if you're unemployed and do not have a job, well, we have a partnership with Lamar University. Well, we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. With that program, the program is designed for individuals to be trained in either the hotel industry, the shipping industry, or the chemical industry. Once they are trained in any one of the areas that they select, then they will assist them in getting a job in the area that they're trained in. If you have not graduated from high school, CICE has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I mentioned are free. It does not cost you anything other than time. And in this court, I like to say we do not just give time, we take our time. And that simply means that we do not just arrest the problem, we address the problem. We believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so therefore, I say that when you come before county court at law number 2, we do not have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in the lives of the individuals that come before this court, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know, and we'll be happy to give you the information that you need to get started in any one of these programs. And the other benefit from participating in the program is this. All of these programs can be used as community service. So for example, let's say you were required to pay a fine and court costs, but you are unemployed and you do not have the income to pay the fine and court costs, then we can convert it to community service. And if you participate in the mental health program with Spinotop, or the drug and alcohol program with ATAR or OZAR, or if you participate in the job training, job placement program at Lamar University, or if you participate in the GED program, for every 1 hour that you participate in any one of these programs, $12.50 will go toward your fine and court costs. 1 hour will go toward your community service. So you are doing 3 things, and you're doing 1 thing, but you're getting credit for 3. That is, I like to say that you're killing 3 birds with 1 stone. You're in the program, you're getting community service, and you're paying your fine and court costs. So if you're interested in any one of those programs, just let us know, and we'll be happy to direct you to talk to the individuals that you need to talk to get in the program. So at this time, we're going to have Deputy Hinton and Chris, who's going to come forward and tell you something about the Spindletop program that they have to offer. Deputy Hinton and Chris.
Thank you, Your Honor. Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the Jefferson County Sheriff's Office. This is my coworker here, Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to the bench. What the judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes a lack of community resources to help with your particular situation.
So as a judge, remember he says no, he means anxiety, depression, things that everyone goes through at some point in their lives. They really all go through things that are not necessarily really easier than being. So the big thing with that is that we connect research, right? There's a lot of really great community resources out there that are well funded, but they're not with contact. Sometimes even just finding them to do that like job business. It doesn't, I know the judge probably mentioned inpatient, outpatient, that kind of thing. We can get you information on whatever you need. But we can also be there as support. Because that's one of the big things there is that this is not a moment that anybody expects to find themselves in. This is not something that's easy, but you all show up. We all know that you work hard for yourself and think it's here. You just want to be here. So we want to use this moment.
So maybe this is your first time to be here. Maybe it's your 10th time to be here. There's still hope. In fact, what we're offering you here today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us. And Chris will explain how to do that very privately.
So when I was ready, you wanted that. Whenever everybody came in, we handed this out, right? Now this is created to function as a baseline for the consent form. The reason it is built this way is so that you know that any information you put on it is like to understand law and say your medical information. The only person who will see this is me. The only person who will reach out to you off this form is me. You get to pay however you want me to contact you. You can take, if you want to talk to me privately today. If the court moves fast, we don't get a chance to talk today, We can set up a time to sit and talk to them. Again, we understand one of the big resources that a lot of people need, it's hard to find, is support, right? It doesn't matter what you need, it doesn't matter if you're here for yourself or as support, it doesn't matter if you need information for somebody you care about. What matters is that you're here and you have this opportunity to help in whatever way you can.
I also have a card here. I want to give you on the, has the 1-800 number on there. If you ever find yourself in that place, you can call that number and get help immediately.
So one big thing about that number is the first resource we can give you, usually in this case, and at some point we'll have to get more. But, the big thing about that number is active almost statewide. Like, we recognize a lot of people come to court in Jefferson County, they're not from anywhere close to here, sometimes not even from Texas. It doesn't matter where you're from, it just matters that you have something that you're trying to find. If you are trying to find a resource, we need somebody to talk to, we can find something in your area. That is active, again, almost statewide, to say that, because there's some dead areas, all of that, we've all driven through them. Outside of that, it is 24/7, you call at 6 a.m. on Christmas Day, and you still get an answer. Again, that's a crisis number, though. If you have something you need, and it's not a crisis, or you just want to talk, that is why I will be reaching out to you, so that you can have that number, you can reach back out to me whenever you need to. I'll only contact you once. This is not gonna be a robocall situation where I just, blow those phones every single day. You guys don't have time for that. But what matters is that you have the right contact information so you can reach out whenever you need something, or just to catch up, just to let me know how things are.
Just a little bit, the court is going to go into recess, and when it does, we'll be coming out there, we'll pick up those documents from you, I'll be handing out one of these here as well. Thank you very much for your time.
Thank you, Deputy Hinton and Chris. Okay, ladies and gentlemen, the paperwork that you have, we're going to pick that up from you in a few minutes. If you need any assistance with filling out the paperwork, we have our court personnel who will be available to help you fill out the paperwork. Now, this is going to take us a few minutes to pick up the paperwork and then for us to evaluate it. And then once we finish evaluating the paperwork, we're going to call you up one at a time before the bench. If you need to use the restroom, there are 2 restrooms in the hallway. The male restroom is next to County Court at Law number 3, and the female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, the court is going to go into recess. Now, if you need to use the restroom, you can use the restroom, but do not leave the courthouse. If you leave the courthouse and your case is called and you do not answer, then your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, for those of you who need help with the paperwork, just raise your hand and the court personnel will come to you and help you with the paperwork. So at this time, the court will be in recess. Have him to come on up. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 0126. Case is styled the state of Texas versus James Bell Zamora. Mr. Zamora speaks Spanish. We have Miss Jennifer Raji, who is our Spanish interpreter. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret English to Spanish and Spanish to English, so help you God?
Yes, Judge.
Okay, you may put your hand down. How are you doing, Mr. Raji?
Good, Judge. And yourself?
I'm doing fine. Thanks for asking. Ms. Araja, ask Mr. Bell if his full name, Mr. Zamora, if his full name is James Bell Zamora. Okay, so I gather just from looking at it, he must speak some English.
Yes.
A little bit, okay. Now, tell Mr. Zamora to raise his right hand. Mr. Zamora, do you swear and affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Okay, you may put your hand down. Mr. Zamora, I have before me two documents. I asked Mr. Zamora if he recognized these documents.
Yes.
Okay. Now, Mr. Zamora, on the first document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line saying you want to apply for court-appointed attorney? Okay. I also have another document that is titled Affidavit of Indigence. Ask Mr. Zamora if he recognized this document.
Yes.
On page 2 of the same document, there is a signature above the line that's titled Defendant. Ask Mr. Zamora if this is his signature. Okay. Mr. Zamora, before you signed and initialed these documents, did someone go over these documents with you? Yes. And did they go over the documents with you in Spanish?
Yes.
And obviously it was Miss Jennifer Raji that went over these documents with you?
Yes.
Okay. Did you ask him if he understood everything that you went over?
Yes.
Ask him if everything in these documents is true and correct to the best of his knowledge.
Yes.
Now, Mr. Zamora, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Okay. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Ms. Araji is going to give you that information after she receives it from our court coordinator. Okay. Mr. Zamora, this will conclude your case. Once you receive the paperwork from our court coordinator, you be free to go, and you have a blessed day. Okay. Please stand right over here. Thank you, Mr. Raji. Case is style of State of Texas versus Valencia Guidry. Ms. Guidry, is that your full name?
It's Gil.
Guillory? How are you doing, Ms. Guillory?
Good.
I'm doing fine. Thanks for asking. Ms. Guillory, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you would like to apply for court-appointed attorneys? I also have another document that is titled Jefferson County Affidavit of Indians. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defender Signature. Is this your signature? Ms. Guillory, before you signed and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Guillory, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. And so at this point, you have two other options. You can either have your case reset to hire an attorney to represent you, or you can waive your right to an attorney and represent yourself. Okay? So what I'm going to do, the court coordinator or court administrator is going to hand this document back to you that's titled Judge's Explanation, so that you can make your choice. If you need some time to decide what choice you're going to make, you can sit at that table right there. Okay? Did he even total this up?
Okay.
Roderick Simon? Mr. Simon, your full name is Roderick Dion Simon?
Yes, sir.
Mr. Simon, would you please raise your right hand? Simon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Simon, you may put your hand down. How are you doing, Mr. Simon? I'm doing fine. Thanks for asking. Mr. Simon, I have before me two documents. The first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And on page 2 of this document, there's a signature. It's titled Defender Signature. Is this your signature? Mr. Simon, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Simon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair by the wall. You're welcome. He's still filling his out.
So she just started working. She hasn't received her first check.
Well, she didn't say that.
I guess she didn't know.
I only, I only know what I see.
I think she went by what she,
That's that, the question don't ask that.
right.
This question say what you took on, what you take on.
Yeah.
Well, she needs to redo it then.
Okay, so let's give her a whole nother one or just.
She
do
can
it
scratch
over?
through whatever. She
Okay.
hadn't received
Yeah.
anything.
Mm-mm.
Oh, here you go. You can, tell her that. You have his judge's explanation. That first guy, that guy. That finished. Yeah,
Yeah.
yeah. Okay. I need to strike that. Yeah.
And then it was not that. Then it was not.
Guillory's gonna be changed. Guillory, yeah, appoint, Benjamin Jeffries. She not, she wasn't making anything. Oh. Max Johnson. Shit, well, it's gonna stop.
Oh.
Max Johnson, you come forward. This is cause number 24CCCR0132, case of style state of Texas versus Max Johnson Jr. Mr. Johnson, is that your full name? Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson? You all right? That's good. Now, Mr. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that cited defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this document, there's a signature above the line that's titled defendant signature. Is this your signature? Mr. Johnson, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Yes, sir. Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair by the wall. Yes. Here we go. It's supposed to be. Okay, that was in the wrong court. You had this guy Knighton on yesterday.